Hi, my dear friends. Punarvas Jayakumar here. So, guys, I'm coming to you with a very important landmark judgment for all CA students. If you remember, 2 years ago, I had posted a video that is ICAI versus CA students, which obviously garnered a lot of views because of our analysis and because of your support. You can check out the video on top or also in the description below. On similar lines, this is one more video, landmark judgment that came on 7 December, my dear friends. I was waiting for the order copy. I've received the order copy, and also I'm very proud to tell you that the student here who has taken on against the ICAI in the High Court was my law student, Nikita KJ. She's a chartered accountant and she had attended my classes, if I'm not wrong, in 2021. So I'm very proud that rather than sitting quiet, she took on, because whatever was her right, she wanted to ensure that her rights were protected and she sought help from the court. So, my dear friends, let's move on immediately. This is in the High Court of India on 7th of December 2023. Again, remember this justice's name because what he has done is really give a lot of hope to CA students. Honorable Justice Mr. M. Naga Prasanna, kindly remember the name. It is very important. So, my dear friends, as you know, we will analyze the judgment carefully. We will understand what it is. I'll show you the regulations. So, please bear with me. Please watch the full video. Do not skip anything. It's a very important video for all the students out there to ensure what your rights are, what your rights are not there, what rights are there for you. Everything you need to know is there in this particular video. So, without further ado, let's go. So, guys, in generally in law, in case there is no way to appeal, the only possible thing as granted to us in the Indian Constitution is through a writ petition. So, Nikita, my student, had obviously applied to the High Court via a writ petition. If you see in 2023, this is my student Nikita KJ. She is the petitioner, and these people would be the respondents. First is the Union of India, that is the Ministry of Corporate Affairs, my dear friends, and then our institute. First is the Institute of Chartered Accountants of India, the main branch, and then of course the membership council, right, that section, and of course the fresh enrollment section. These are the respondents, so to speak. So this would be falling under Article 226 and 227 of the Indian Constitution, where you can apply via writ petition, praying for upholding of the rights as an Indian citizen. Every Indian citizen has the right to ensure that justice will prevail. So very simple, guys. What had happened, gist of the story, though we will go into that in depth, is there is an regulation, right? There is a regulation in the CA regulations, which is regulation number 65. So, according to regulation number 65, if you are doing articleship, right, of course, you will be doing CA course. Along with that, you can just do one additional course. That's it. One additional course. Mind you, this is during articleship. And after the articleship is over, you can do whatever you want. Before, obviously, no one gives a damn about it, because what really matters is the idea is very simple. The rationale is very simple behind it. When you are doing articleship, you are anyway doing CA. You will not have to. You will not have time to do multiple courses. So the institute allows you to do only one course. Okay. Now, this lady, my student Nikita, she had already finished CA foundation. Obviously, that's the reason why because this was her CPT route. In the CPT route, she has to finish foundation, inter, and then join articleship. So obviously, CA foundation was over. She had finished obviously CA inter. Why? Because that's the reason why she obviously will get into articleship. She had finished CMA foundation and CMA inter also before articleship, mind you. And she had finished her CS executive also before articleship. And she had just taken up BCom. Got it? This is the sequence. She had already finished all these things and she has just taken a BCom. So at the CA inter level, where I finished CA inter and I'm joining articleship, I've already done foundation, obviously, inter, obviously, CMA foundation and inter already over, CS executive also done. Plus I'm doing BCom. Now, when I have joined articleship, I can only pursue one course, right? Only one course. So Nikita chose to pursue BCom. She didn't want to do other things. She didn't want to continue that time until she finished BCom. So she took up this particular thing. So let us see, my dear friends. So facts adumbrated as follows. Adumbrate means explained. right, in legal parlance. The petitioner is a student. In the month of May 17, see, she joins BCom degree and she has already enrolled herself in CMA Foundation. She completes her CMA Foundation, CMA Inter, CS Executive also done, and she completes in 2018. Okay, in 2017 she joins BCom. So BCom she can do, no problem. Now, on 27/8/2018, guys, she joins articleship. Mind you, at this point in time, she has finished CA Foundation, CA Inter, CMA Foundation, CMA Inter, and CS Executive. Because that time, if you had cleared CA Foundation, there was a direct entry to CS Executive. So she had finished that also. Plus, she was doing what? BCom. So you need to file a form called 112. So if you see the CA regulation here, under regulation 65 and 78, an article clerk, audit clerk is required to obtain prior permission before engaging in other course or studies or engagement in business or occupation. This is only when you join articleship. So was Nikita required to take any permission till she joins articleship? The answer is a resounding no. Goes without saying. Now the permission was granted. So now what is she doing? She's doing CA Inter and she's doing articleship and she's just doing BCom, nothing else. CS final is pending, CMA final is pending, of course CA final is pending, goes without saying. She finishes her BCom degree also, my dear friends, in September 2020 she finishes that. And now since BCom degree is over, what will she do? As per the rules, regulation 65 talks about form number 112, all that we have to sign that. In that she has taken a permission saying that I now want to write CMA final because she had already finished CMA Foundation and Inter. So institute gave permission, mind you, institute knew, okay, this lady has finished BCom. Now let her do CMA final. They have granted permission already. The petitioner in December 2020 completes her CMA final exam as well. Right? I remember CMA final you cannot write without articleship if I remember right. But that time it was COVID. So during COVID I remember because many of my other students also had taken up. So there during COVID there was the exemption for articleship and all those things. So basically she took permission. See, she took permission. They granted permission and she wrote the exam. She cleared also. After the completion, petitioner on 33/21 again seeks permission to pursue additional course, which is this CS Professional. Why? BCom over, CMA over, CS was pending. Now CS she wants to do along with CA, that professional course. That also they gave permission. Of course, she was continuing it on completion of all the courses. Then she said, okay boss, I am a CA, CS, CMA, everything. I am a BCom graduate also. I want what? Permission now to become a member. Because she cleared the examination in 2023. So she's like, I want to become a member now of the institute. Our institute sent one letter saying that during the course of your entire CA journey, you have done multiple courses. You have done CMA, you have done CS, you have done, BCom, everything. Not allowed. So for that, as per the regulation, you have to pay 10,000 rupees fine and there will be a 2-year waiting period. Guys, think about it. I am ICAI, I gave permission. Now I am telling, no, you have done multiple courses. So the question was, why did you give permission? So Nikita, she said, respectful sirs, why did you give permission if that be the case? And the regulation is very, very clear, sir. Only before what? An odd article clerk. When will the article clerk scene come? Once you join articleship. Before that only I had finished all those things. So I no need for me to take permission for anything that happened before. And no need to take permission for anything happened after. The only rationale of articleship is what? During articleship, you will be doing CA, so you will not have time to do many things. So just do one more. So she said, sir, during that articleship period of 3.5 years, BCom was already 2 years over. I completed BCom, then I completed CMA final, then I completed CS professional also. I am a triple, qualified person now. 3 qualifications I have, plus BCom also I have. So why do I need? I have taken permission. Have I cheated you? No. Have I kept quiet? No. I have taken permission from you as per the regulation 65 and 78. I have filed the form 112. What is the problem? Right? So the thing was, this was what it was. If you see regulation 65, the regulation that operate the field which bars multiple courses being pursued by the student. Yes, it bars multiple courses who has enrolled for articleship after articleship. After articleship, you can only do one at a time, and that's what she did, one at a time, as simple as that. Right? So this happened they are still arguing that no, she had done multiple courses, etc. She's completed all these things, so it's not allowed, etc. So here they said they granted permission. See, the permission letters also have been clearly mentioned here. Outside the normal working hours, you can do only one other course. Every letter she has produced, everywhere they have agreed. So the petitioner then submits everything to them, all these letters in 2023, 10th February, hoping that she will get the membership number, but they said no. They gave clarifications, they sought clarification, same thing she sent again, and they said 2 more years waiting period. Guys, if you don't get the CA membership number, then you can't apply for other membership also. And because she wanted to pursue, she is a chartered accountant. Other courses she just did for knowledge. That's it. So the gist of the decision, it went to the disciplinary committee, so to speak, and the membership council decided that it is definitely a violation of the respective article, and definitely you are not supposed to give membership. You have to wait for 2 years. So she again literally went and begged, saying that I had completed all these things before, and mind you, in CMA intermediate she got AIR 26 also. At the time of joining CA Inter articleship, she had already finished CA Foundation, CMA Foundation, CMA Inter, CS Executive, already done. So she is requesting that please give me my membership number. She has clearly told there is a delay, and she told very clearly, you see, as per my understanding, I have taken prior permission for every single course during my articleship tenure. So it will not come into the picture at all. Delaying the grant of membership post qualification, quoting reasons which are not applicable to my case, makes me feel that I am being penalized for being well educated and law abiding. Guys, this is a key word. Did she cheat? No. She abided by the law. She could have actually not told only to the CA Institute. Later, for them to come to know, again, she did not even give a chance for any of these things. Every single time, she only went and told, yes, I am doing this, please give me permission. So again, institute said not possible, and institute said wait for 2 years and pay 10,000 rupees fine. So I'm sure, generally you would say that let's not go against the institute and let's wait for anyway just 2 years. But then guys, our rights, when will it be upheld? So you need to salute CA Nikita for standing up for herself and standing up for every CA student in our country. Because the rules are rules and rules are equal for everybody. If you say that after articleship I have to take permission, I will take. Now you are saying you have to take, you cannot do anything when you are doing CA. How fair is that? So yes, the judge, now comes one of the best decisions that I have seen, with amazing language and clarity of thought by the Honorable Justice. It says, act of the student is that on every occasion the student has diligently sought permission from the second respondent, that is the ICAI, to pursue the course. On every occasion the student has been permitted to pursue the course. Like, boss, you have given permission. Now you are saying it's not allowed. Then why did you give permission? As simple as that. Now when the time came to register, the respondent, that is the ICAI, wants to put the clock back by 4 years, tinkering with the permissions already given. You have already approved, boss. Now you are telling it's not there. What is this? It would have been altogether different circumstance if the student was not at all diligent and she did not even ask permission. Then yes, then I agree. I say I agree. So it is not that allegation at all. And you see the way the judge writes, guys, it's all about the language. The mighty respondent. Who's mighty respondent? ICAI. They are telling you are just showing your power here, nothing else. It's just ego, perhaps. Right? Why so much ego? She is your member. She's a student. She's now a chartered accountant, for God's sake. Right? She is a person who has studied, really has a lot of knowledge, and she has come to the institute seeking membership so that she can be a respected professional in the industry, giving great service to people. And out of the bunch of around 3 lakh CAs that we have across the country, of the population of 140 crore, she's telling, the judge is telling, boss, why? Just give the permission. Has she not taken permission every time? Yes, she has. Then what is the issue? Are you understanding? So if you see, who wants to jeopardize the career of a student? Wonderful. She's already a chartered accountant. She's seeking membership. You are jeopardizing her career. And that you are telling that she has not properly accorded permission or permission was not sought, etc. This act of the second respondent sans countenance. Sans means without. And countenance means there is no support to this argument. They are telling this act has no support anywhere. Correct? It has no locus standi. Locus standi means what? No right to do it. That's what he means. This court is dealing with a fervent cry. Fervent means what? Almost desperate cry of the student who sought to pursue multiple courses, develop such acumen, such skill, such knowledge, and she has completed all those courses with the permission of the second respondent. A student will not know the implications of law, my dear friends. A student knows only to study and ponder over the study material which she has done. She has studied and completed the courses. Then he goes on to tell a very important thing. It is rather surprising that ICAI wants to stifle the career of a student. Wonderful language. You want to cut short the career of a student. You want to jeopardize. You want to just pull the student down. Mighty ICAI are pulling the student down. Wake up is what he's actually trying to tell. Who has pursued multiple courses and gained such acumen to practice as a CA. She is choosing you, ICAI. She doesn't want CS, CMX, she's choosing you. Because you were the first for her, then, now and forever. So wake up. It would be helpful to the institute and the society. Right? Societal concern here. If a student has extra acumen, obviously guys, tomorrow if you go to Nikita and ask her stuff about cost and management, she can say I'm a CMA. You go and ask about, your RBI regulations and FEMA, she says, yes, I'm a CA and a CS. Than the chartered accountantship alone. So don't be, hung up on the thing that you are some great institution. Yes, you are great, but look at the other things also. Such acts of the second respondent against a student who has only studied and done nothing else, and that too after seeking permission, that's the best part, would not behove the second respondent to be a state under Article 12. Wonderful, guys. If you see Article 12 of the Indian Constitution, what does it say? Unless the context requires otherwise, who can make the law? The state. State includes the government and parliament of the India and the government and the legislature of each of the states. So the state means your state legislature, state means the parliament, state means the government, and all other local bodies also can make the laws accordingly. Other authorities within the territory of India, is ICAI other authority to make such regulations and deny you membership just because you took multiple courses, and that too by not, disregarding any law, by following all the laws? They said emphatically, the court has told ICAI, you are not a state as per Article 12. I am sorry, you cannot make these rules. The writ is very much valid. Whatever defense that the council has by invoking 65, etc., was for final. The institute told, sir, but we gave permission for final course. We did not give permission for, your inter, and we did not give permission for foundation. Judge is telling, bro, if she has joined final, obviously it means she has finished inter and foundation, right? Right? It's like just arguing for the heck of arguing. You see? The argument that final courses was granted and not foundation courses is a contention skating on thin ice. Wonderful language. As the foundation gets subsumed in the final, obviously, and permission is granted, and pursuing final means I've already granted permission for inter. Therefore, the court repels. Repel means what? I'll throw you out. I'll throw out the submissions. Repels. Mosquito repellent, like that, repels the arguments of the learned counsel for the predictus reasons. Means these are all old reasons, illogical reasons. Predictus means illogical. Wonderful language, guys. Illogical reasons. I deem it appropriate. What a language. Bending the arc of justice. Justice, lady justice who holds the entire weighing scale. Now I'm going to tilt the arc of justice. I'm going to tilt it towards whom? Towards the student, and direct the grant of membership to the institute without brook any further delay. Wonderful language. So the following is what? Petition is allowed. Communication dated 1/5. So guys, she went to the court. There was a last hearing sometime on 2nd, 3rd December, and immediately they gave the judgment as well. Correct? The communication order dated 1/5 issued by the third respondent stands quashed. What is that? Communication saying that you will not get the membership. A mandamus issues to the second respondent to consider addressing of the grievance of the petitioner. Mandamus is where the higher court can order the lower authority to do certain things. It's a writ of mandamus, right? And what? The order shall be passed within 4 weeks from the date of receipt of the copy of this order. 4 weeks, that's it. 7 December, 4 weeks. So by the end of this, maybe by 7 January, my dear student CA Nikita KJ, who is also a CMA, CS, and of course a CA and a BCom graduate, should be getting her membership number. So the day she gets her membership number, I'm going to meet her and I'm going to congratulate her. I'm going to click a picture with her because I'm extremely proud, because she could have just waited for 2 years. It's okay. Anyway, you don't need membership number to join any company. If you just show that you're a CA, it's enough. But she said, no, enough is enough. I need to really stand up for myself and stand up for a lot of CA students who always have this problem. And personal opinion, I feel institute, it's a play of ego. I feel they should not do this. They have other things to do. On one hand, if you see, they have made a mess of the new syllabus, but they've come out with very good subjects, no doubt. But they made a mess with respect to SCMP, law, and they've made it self-paced online module. The predominant idea was to ensure that CAs only learn accounting properly. Company secretary course will concentrate more on company law. CMA will concentrate more on costing. CMA and CS people have not removed anything in their syllabus, but our fellows have removed here, right? That's what it is. And anybody who speaks something against the institute, defamation, right? It's like they're acting like this bully, if I may ask, sometimes, right? With my deepest respect to my mother, CA Institute, sometimes the people there, unfortunately, are giving, some of them, again, mind you, please mind my words carefully, some of them there is a play of ego. They feel that, no, we are only right. Guys, this student has done all the courses and she's begging the CA Institute, the alma mater, to give her the membership number, and for that so many things. On the other hand, they have diluted company law and SCMP and they made it to self-paced online module, diluting it, thinking that other institutes also will follow suit, and nothing has happened there from whatever sources I've got to understand this from. So where are we heading is the question that we need to understand. I always tell this at all forums, because we as chartered accountants have to raise our voices if the CA Institute is doing anything against members or the students. If it's detriment to the CA profession, we need to raise our voices, and we will. Nobody can stop us. We have the constitutional right to do so, right? So having this superiority complex and inflated ego is not good for the CA Institute. So I would humbly suggest that the few of the people who are taking care of the institute there at the helm, and the others who are sane and others who are really, have the foresight, should definitely guide these few bunch of people who are taking these decisions, and they should also do everything which is for the benefit of society, benefit of the members, benefit of the students, always. So guys, I want you guys to give your comments on this particular video to understand whether you like the decision by the Honorable Justice M. Nagaprasanna. Please remember the name. Hats off to you, sir. Thank you so much for a wonderful, wonderful judgment and upholding the spirit of law and upholding the spirit of every CA student for years to come. And I especially congratulate my dear student Nikita for standing up always for herself and for the fraternity, and making all of us very, very proud. So on that note, please drop in your comments, like the video, subscribe to my channel. On that note, take care, my dear friends. Bye.